Hello, this is Dr. Herskowitz. Now we're going to be looking at Chapter 4. We're going to be talking about the actual legal process, the trial itself, and what happens, who the different parties are. The learning objectives on this will be to understand the litigation process, to discuss how issues such as standing, personal jurisdiction can affect litigation, make sure that the court has subject matter jurisdiction, to understand pretrial procedures, recognize the major trial steps in a civil trial, and to appreciate how cases are decided and the process of appeal takes place. There'll actually be 2 videos for this chapter. Okay, litigation. This is the process that helps the business community to resolve actual disputes. It's a lawsuit, which we've all heard about. Effective business leaders should develop a clear understanding of what the process is so that they know what they're getting into if they ever decide to take on litigation, or what the responses will be if they are having to defend litigation. Any lawsuit is an immense, and I say again, immense drain of time, money, and energy on everyone that's involved. You do not have, in business, you do not have small, insignificant lawsuits, maybe some small torts that the lawyers handle, but anything dealing with the company itself is a major drain on the resources of a company. Okay, the parties. The plaintiff is the party who files the action in a civil lawsuit. The defendant is the party that's been sued by the plaintiff. It's a person against whom a criminal charge is filed by the state in a criminal hearing. The counter plaintiff is a defendant that brings a counterclaim against the plaintiff. So the plaintiff sues the defendant that has been sued by the plaintiff will actually have a claim back against the plaintiff themselves. They not only say, I didn't do it, but they're going to say, in fact, it's not even my fault, it's the plaintiff's fault. And so they become a counter plaintiff. Third-party defendants are parties brought in by the defendant usually to complete the determination of a controversy. So the plaintiff sues the defendant, but the defendant says, I wasn't the only one that did this. There's this other party who is also involved, and they're going to be liable themselves. So that is a third-party defendant that is brought into the action by the defendant, not by the plaintiff, because the plaintiff would have named them as a defendant in the beginning when they filed the action. Okay, you have to get into court. To get into court, there's 3 key things that you have to have. First of all, you have to have standing to sue. That means that there has to be some issue that is before the court that's real, not just a theoretical one. You have to have subject matter jurisdiction. The court in which the plaintiff brings the action must have the ability to hear that subject. For example, you would not bring a bankruptcy case in a state court. They do not have jurisdiction over bankruptcy matters. And finally, there must be personal jurisdiction. Personal jurisdiction means that the court itself has the jurisdiction over the person, over the defendant, because the plaintiff has come into the court. They must have the personal jurisdiction over the defendant to legally, through the due process of law, to bring them into court. And you have to have all 3 of these to be able to get into court. If you're missing any one of them, the defendant will move to dismiss the case and win. Okay, standing to sue. That establishes that the plaintiff is entitled to have a court to decide the dispute. Litigation must involve a case or controversy. It's not a theoretical idea. There's something that actually happened to the plaintiff, and they have a personal stake in it and in the resolution of the controversy, if they're going to have the standing to sue. Look at the case of Spokio v. Robbins that talks about the individual having a standing to sue. There's an interesting case in Meyer v. Belichick dealing with the New York Jets. This was somebody that was upset that they thought Belichick was cheating, and they were one of the people watching the game, one of the fans, but the court said that they did not have any legal right out of the alleged dishonest videotaping. Therefore, he could not bring the action himself. Personal jurisdiction. The court has authority over the parties of the case with physical presence of the defendant in the case. So if there's two people in Oklahoma, they sue each other, they're both within the state. A summons is a notice to appear in court, service of process. This has to be served upon the defendant. There's a whole process about it, and it has to be done correctly to make sure the due process is being taken care of. If a defendant is not in the same state, is not in the same jurisdiction as the court, then there are some long-arm statutes that will allow the court to reach out across outside of its own boundary, its own territory, to find that another person can be forced to come into court. And that is if the the defendant, has committed a tort within the state, then the court can reach across state boundaries and say, you've got to come back here and pay the piper, you've got to come back and defend yourself within this jurisdiction. If there's property that's owned within the state, even if the owner is outside the state, that is subject to the matter of the lawsuit. And if the person has entered into a contract or transacted business within the state. That's what's called the long-arm statute. Long-arm statutes have grown a lot since 1945 with International Shoe v. Washington. That says that if a company is doing business, if they have minimum contacts within the state, then the court can get jurisdiction over them. And so that there's a whole series of cases, but you have to have minimum contacts to be able to get personal jurisdiction over a defendant for a legal action in the state. Subject matter jurisdiction is that the court itself has the right to hear that issue that's before it. State courts may hear any matter not preempted by federal law. State courts cannot hear exclusive federal issues. Federal courts cannot hear issues dealing only with state matters. Even within the various court systems themselves, like the federal system, there are specialized courts. There's tax courts, there's a bankruptcy court. In state courts, there's a small, for probate, and there's other court systems that are just only limited to what that subject matter is. The district court has general subject matter jurisdiction. It can hear any matter that is qualified under the federal law. Okay, how does this case proceed? Well, you start off by having pleadings. A pleading is a fairly formal document that sets out all the different claims that the plaintiff has against the defendant or defendants. The defendant will then answer that, either admitting to certain things or certain facts that are not contested, or then denying certain other facts that will end up being the issues in the case. Then there are pretrial motions that the judge will hear. This is where the defendant is saying that there's certain issues that will maybe just kick out some claims, maybe even allow them no longer to be there, such as a statute of limitations or something like that. Okay, you then have discovery, which is usually a very long process. We're going to talk about that in greater detail in a minute. Once you go through discovery, you have pretrial conference. This is after all the discovery is done, the plaintiff's lawyers, the defendant's lawyers, they all get together and then in front of the judge or a magistrate, and then they try to work out what are the issues that are going to be determined at court. Maybe at this point the parties will offer to try to settle the case. But if that doesn't work, pretrial conference is finished. It sets up the date for the trial, the issues there. You then actually go into the trial itself. And that can take from 1 day to several days to several weeks, depending on the complexity. The trial is usually in front of a jury unless both plaintiff and defendant waive that, and then it would be a trial only in front of the judge. You then have post-trial motions where the losing side says we should have won, and then either party or both parties may then bring an appeal to the next higher court, from the district courts to an appellate court. And then from the appellate court, they would do a writ of certiorari to the U.S. Supreme Court if they wanted to appeal to the Supreme Court. So pleadings are legal documents that are filed with the court. There's the complaint filed by the plaintiff that lists all the different details of what happened to them. The answer is a written pleading. It's a complex case. The attorneys work together making sure there's a certain time period that you have to do an answer. If you don't answer, there could be entered into a default, and that then means that the other side automatically wins because you didn't come to court. So you must answer the complaint. After receiving an answer, the plaintiff files a reply that admits or denies each allegation of the defense counterclaims. It's kind of going back and forth on this. Discovery then takes place, ensures the results are based on the merits of the controversy and not just the oral skills or the ability of the counsel. It should narrow the issues of disputed parties. They'll discover what they know, what they agree to, what they don't agree to. And it also encourages settlement. Types of discovery, interrogatories, this is important. Interrogatories are written questions presented to the opposing parties. So the attorney on either side will have a series of questions asking the other side if this is true, if it's not, or explain this. Those are usually filled out initially by the defendant or the plaintiff, and then the attorney reads over them and makes them so nebulous that they really have very little meaning. The request for production of documents is very important. This is where either party can ask for copies of documents that are in the other party's hands. There's a lot of dispute on that at times about privileges and stuff like that. And the judge or a magistrate, which is a junior judge that works in the federal system, will rule on whether or not these items have to be delivered or not. Depositions, one of the strongest tools in the discovery. It's the lawyer asks questions orally under oath of the witness. It is a sworn testimony, and that testimony can then be brought into court to either confirm or say that you said this when we had the deposition, and now you're saying something different, so you can use it to discredit the witness if they try to change your story. As I said, depositions are oral in front of you have the plaintiff's attorney, the defendant's attorney, whoever is deposing the other party. The party has their own attorney there. There's a transcript recorded by a court recorder. It's then signed as authenticated by the person who's had the deposition. Depositions are of defendants, depositions are of plaintiffs, and depositions are of witnesses. So they're not part of the case, but they're going to be called, and so the attorneys can ask them all the different questions that they have as well. And sometimes these transcripts are videotaped so that the jury can see the tone and tenor of the types of answers that the witness has given. As I said, the witness will always have their attorney there. The attorney may object to some of the types of questions, and then the judge later will rule whether or not that was admissible or not. It's less formal than with a trial, but is very important. Discovery can be very broad. You can ask a whole bunch of questions, but only some of it will get actually into the case itself. But discovery is very expensive. But some attorneys abuse discovery and use it to try to beat the attorneys of the opposing side into submission through the cost. I will say, because of my experience in Belize, even though it's a common law country, they do not have any discovery. The cases are resolved very quickly, but it is a very terrible system. Discovery really does allow the parties to find out what's really going on. And so it's a very necessary evil. And it will make the case much better. You do not want to be in an environment that you cannot discover, and you just have to kind of say what a person says, call them up to on trial and not even know what their answer is going to be and have no proof to disprove it because you've had no discovery. Statute of limitations would be a motion saying that the defendant admits that a suit started too late, that the statute had passed. There's judgment on the pleadings, and then there's a summary judgment where after discovery the parties say there are no issues that we dispute, and they turn it over to the judge to make a decision. Okay, now we're going to go into the trial steps, and we're going to do that on the next video, chapter 4b. Thank you very much.